Dan Lust. Dan Lust now, sports law attorney, joins us on 365 Sports. Dan, thank you for your time with Craig and Paul and David Smoak on 365 Sports. So what do you think about, now there's this latest thing, this Collegiate Athletics Association, about they want to do all these things and get all this stuff, but they don't want to be employees. It seems like universities don't want athletes to be employees either. How does this all shake down in the end?
So I guess a couple points, and I was listening to the last call. I think there is some misconceptions in the market that students need to actually unionize to and be involved in the system of revenue sharing. That can come really from a state law. It can even come by the NCAA just kind of lifting these prohibitions by the school directly paying the athletes, which we're seeing right now. It seems to be from reports in the works in the Big Ten and SEC conferences. So, certainly being an employee comes with positives, right? You can collectively bargain, but also the negatives, right? That you can get cut. We can go through that whole laundry list. But certainly there does not need to be a union, and there does not to be employees in order for there to be some system of revenue sharing. So I think that's the main thing I'm missing people say, but that can happen at the state level. It can certainly happen at the NCAA level.
Dan, with House versus NCAA, rapidly heading towards a settlement. In fact, some reports have it coming as quickly as maybe in 40 days, which I'm sure is so many billable hours that they're going to have to add to the settlement just to get the lawyers paid for. But what do you think is the offshoots of that, and how the NCAA reacts to having to pay that money and try to avoid cases like this constantly popping up?
So I guess I'll say this, which I haven't really heard much on the rounds. I've certainly seen the reports that House versus NCAA is barreling towards a settlement. And, I've certainly seen that. But we have to keep in mind, right? And I'm not aware of the actual financial arrangement between the plaintiffs in that case and the law firm. But by and large, these very large cases with a large monetary amount involved will have some form of a contingency. If the law firm settles a case, for example, for $100 million, they'll get some percentage of that recovery. It's not every firm that does that, but most firms have some type of a contingency on a case like that, especially a class action lawsuit like we have. So the law firm involved, in order to take a settlement, as has been being reported, which is not really a high monetary settlement, I'm sure has some millions involved, but really the NCAA is asking for a haircut on the price in order to agree to the system of revenue sharing. So I'm not quite sure how the law firm agrees to take a haircut there if they would otherwise get a piece, right, of a settlement or a verdict, which is being talked about having exposure in the billions with a B, why they would agree to take a haircut on the finances for the greater good of college sports. Yes, I think as fans you would understand that, but that doesn't, as a lawyer working in a law firm, that doesn't really sound typical of what a lawyer would do in that situation. So I want to maybe temper people's expectations that this is certainly a virtual certainty. If it happens, it's a tremendous feat of the law firm to kind of give up fees, as my understanding of it would be. But yes, I am hearing that time frame. I think there's a trial date right now in 2025. People are circling. But if we do have a settlement here, that would be mountains moving to get this done, which I don't know how realistic that is, but certainly I do have some questions about this time frame people are talking about.
Dan, and with that doesn't mean that everything's just good to go for the rest of time, right? This is just basically plugging the well, and there will be leaks again. It's just a matter of there might not be leaks for at least a few more years as opposed to leaks every other week, it seems like, in college sports. Am I reading that correctly, or is it a bit more complicated than that?
No, I think that's fair. I mean, this House versus NCAA case, if I can distill it down to 10 seconds, right now, the NIL deals are allowing athletes to be compensated for these kind of third-party marketing deals. So an Instagram post, you do an autograph signing, anything where your NIL is being exploited. For whatever reason, the current definition of NIL nationwide doesn't encompass broadcast revenue. So that's a large piece of the revenue pie that schools are making, which seemingly involves players' NIL, right? When we watch March Madness, we watch college football, players' names, their image and likenesses are being put on TV, and the schools are getting a check cut for those television deals. So if you just ask someone, if you're exploiting someone's NIL, does that include television? There's certainly an argument that it does. But that case being settled takes that off the table, and there's not now billions of dollars at risk. And it's maybe like one other arrow or one other bullet that's not going full speed at the NCAA. So it solves one problem, and there's still several others that are kind of looming out there. But that's the big monetary case that people have been looking at.
Dan, what do you think ultimately keeps them out of the courtroom?
Their viability. I don't think they can. I don't think they can go to court with $4 billion in exposure with treble damages and a class action lawsuit. I mean, at a certain point, you have to cut your losses and try to find a way to survive. But I don't know. I hopefully hope people don't read into this, but I believe, and this is just my opinion, I don't really know this to be the case, but most law firms would take a class action lawsuit with $1 billion exposure. They would take some form of a contingency. So if a law firm waived their fee there for the greater good of college sports, that's like a tremendous story that I don't quite think is being reported. And the likelihood of that happening, it's not often. Just for point of reference, right? I think you guys remember there was this big city of St. Louis versus the NFL, where the city of St. Louis was suing the NFL because the NFL allegedly took the Rams out of St. Louis and moved them to Los Angeles. So there was a lot of conversation. Hey, what if the NFL offered St. Louis a franchise, expansion franchise, instead of having this $1 billion and $500 million in exposure? What if they offered them like City of St. Louis $10 million, but they gave them an expansion franchise? And that was on the table. I think, certainly we were talking about it. It was in the lexicon. And in the end, the lawyers took the big wad of cash. I think they settled for like $740 million. The lawyers took a third of that. And lawyers left happy, and City of St. Louis was left without an expansion franchise. So not that it was necessarily on the table, but certainly in the realm of discussion. So that's the type of conversations that are occurring now between the law firms for House and NCAA. If it happens, it's a tremendous, landmark settlement, but I'm not quite sure how realistic it is at this stage.
Dan, do most attorneys with their clients want to settle rather than go to court, no matter if it's even like a fender bender?
Depends, right? There's a saying that people say it's not, the numbers don't line up exactly, but 99.9% of cases settle. Sometimes you just want to alleviate that risk. And if you sometimes, and I won't mention it, the case in particular, but I've been, representing a defendant in a lawsuit. They were being sued for millions of dollars. And sometimes, right, you can't pay them millions of dollars and you just want to, take it to court, right? Sometimes you do that, but you'd obviously like to settle. It alleviates that risk. But if you think you have a good case and the other side is not giving you a settlement offer, taking into account the strength of your case, sometimes you don't have an option. So I'm not sure the NCAA has the funds to offer, we'll say $1 billion. They don't have that. So they have to get creative. But I would think most lawyers are risk averse, and plaintiffs lawyers, if you're getting paid on a contingency and you have nothing to lose, by all means. But I think defendants, by and large, you'd rather settle a case than go all or nothing and risk the company.
For the ACC now and their battles with Florida State and Clemson, and then ESPN obviously involved in this, there's a lot of things that seem like a big deal or maybe aren't a big deal. I know that FSU had to refile their case, but Clemson did just get an opportunity to see the TV contract while keeping it confidential. Is that bad news for the ACC, or is that more procedural than anything?
It's probably bad news for the ACC, but I don't think it's like a death knell by any means. These cases, when they're brought, unless there's some type of pre-answer motion to dismiss and you don't have a right to sue someone, or contractually you're not allowed to sue someone in open court, generally courts are inclined to allow some level of discovery between the two parties. So from my understanding of the Clemson case, that's all this is. It's just hey, we will let you see this TV contract. You can only look at it for a certain amount of time. You can't, we don't want this getting out to everybody, but we're going to let you at least have a look at this for purposes of building your case. So to your point, I think it is generally procedural. It doesn't speak to the substance of the case, but most parties to a litigation, as a plaintiff on day one, you don't have to be able to prove your case. You need to have a colorable case to get into court and allow for discovery from the other sides, be it contracts like it is here, text, emails, phone call logs. So this is really step one of the battle. I'm not quite ready to make a prediction on it yet, but the fact that some discovery is allowed, I would think is probably bad news for the ACC and good news for the schools involved.
Dan, when the O'Bannon case settled, or when that was won by O'Bannon and I guess his attorney, and then, of course, Alston, Jeffrey Kessler, and that lawsuit was won by him too. I don't know if you were in law yet or you were actually a practicing attorney yet. What would you have suggested back then to the NCAA that this was only going to get worse?
I mean, the writing has been on the wall since that case was decided. That was a case decided in California. And, you mentioned the Alston case. That's a West Virginia running back that decided to pick a court in California to sue the NCAA because of that positive Alston case law. And I know we've spoke about this in the past in prior, interviews, but this has all been started by that case happening. And I believe that was decided in, I think, 2008, 2007 in that ballpark. Correct me if I'm wrong. Maybe it's close. 20 in the last 10 or 15 years, right around there. The fact that we have this disjointed landscape with different state laws has happened because these states wanted to do what the NCAA wasn't, seemingly unwilling to do. If the NCAA had acted and they had done all these various solutions that they're trying to come up with at the 11th hour, states would not have felt inclined to put this on their legislative docket. So this, not that the NCAA could have solved this, but this disjointed and fractured situation with all these different state laws, that's a problem of the NCAA's own making because of their failure to act in the decade that passed since the O'Bannon decision, which said that the NCAA is not allowed to control players' name, image, and likeness without paying them. So that gap of 10 years, that's the NCAA's own doing.
Yeah, it's amazing. It's just like they keep butting their heads against the wall because they felt like, well, eventually they're just going to believe what we think is right. And obviously it's only gotten worse and worse. Does any day surprise you anymore with stories about what might happen in athletics?
Not really. I will correct the record. I think O'Bannon was a 2014 case. So We'll give the NCAA about 6 years or so. It's not that it's good, but it's a little bit better than 10 years. I think at this point, and I certainly don't blame people in the space, we have so many different days of news. This is the next big proposal. This will save the NCAA. This settlement will save the NCAA. This new case will kill the NCAA. This one will kill it. It's almost kind of white noise at a certain point because we have so many bullets and arrows pointed at the NCAA, and everyone said the NCAA is going to die tomorrow and they're going to cease to exist. And I don't know, they're still kicking, right? There's still 3 years into the NIL era. Certainly you see the writing on the wall of the NCAA not being in existence maybe 10 years from now. But we have so many different news cycles, so many news reports, and they're all basically saying, at some point the NCAA will cease to exist, but we're not quite there. Do these news cycles cease to amaze me? No. I think there's been creative ways, and I think the floodgates are certainly open for people getting creative in terms of why and how they want to sue the NCAA. Even, this past week, St. John's, a school, in my neck of the woods in New York, has a new lawsuit against the NCAA to get additional years of eligibility for some of their athletes that went to Ivy League schools and lost a year during COVID. So between the transfer portal, between years of eligibility, broadcast rights, every single direction that you could come after the NCAA, people are doing it. So at this point, all bets are off. But I think we just have to find a correct line for the over/under of the NCAA's viability.
Have you ever met Jeffrey Kessler?
I have not. I have spoken with his colleagues, some of them I know very well, and very appreciative of his contributions to sports law. So I have nothing bad to say about Kessler. We would call him a godfather of sports law. So only good things to say about Kessler.
Dan, for the ACC and their fight to stay together, which will be hard if they lose any teams, and they probably are because Florida State and Clemson are trying to find their way out. Do you expect this to go to trial at all, or do you expect this to get settled?
Well, this is one of those cases where if you let Florida State out, right, or you let Clemson out, the floodgates are certainly open. So, I don't think this is a case that is so ripe for settlement, right? You can't just Florida State can't just pay a certain amount of money to get out and vice versa. It's just kind of the nature of the beast. And for both of those cases, basically the dispute boils down to a contract that all of the ACC member schools sign, the various, exit payment they'd have to do if they left the conference, and this television deal that apparently everybody agreed to. Those are the two finer points of the deal. And from the law's perspective, yes, you can argue that you had a bad deal, but if at the time your legal counsel, looked at this contract and they said this was okay to accept or these exit fees were fair, it's a tougher argument to the court to say now 5-6 years later, these contracts should be unenforceable. So it's not a case where the ACC is going to be quick to settle it. And if you're Clemson and Florida State, if you filed a lawsuit trying to get out of this deal, I'm not quite sure what has changed in that period of time. So both sides are trying to enact leverage, but I don't really see a direct route for these cases to settle. Same thing with House versus NCAA. I'm not as convinced maybe as the public that case is so easily to settle. Yes, somebody leaked this to the press, and I guess the parties are working on it, but it just doesn't seem on paper a case that so easily avails itself to a settlement, whereas like a car accident case, right? Someone's hurt, they got a banged up neck, they got hospital bills for X, they can't work this many days. Like, okay, we can do some math on that. But saving college football and trying to find a solution to compensate people for $4 billion, or the amount of money lost by Florida State and Clemson or being part of the ACC, it's not as easily calculable as some of these more less complex lawsuits.
If you don't mind, the question from the chat from Barry. Ask Dan, if football players do become paid employees of the university, would that remove them from Title IX?
Would it remove them from Title IX? I think it depends on the particular context, but I think for whoever asked that question, I think it was Barry, there is still a looming Title IX concern in this current landscape of collectives, right, paying these athletes and these NIL deals when the collectives are not subject to Title IX. So if the payments somehow move from school paying athlete, then those payments and the amount of money that athletes are getting via the school will be subject to Title IX. So I think that's what Barry's asking.
Yeah.
But that's right now it's a problem or a gap in guidance. Collectives are paying these, men's and women's sports, and there's really nothing guiding the collectives to have to be bound by Title IX to have equal distributions across sports. Whether it's good or bad, there's just nothing covering it right now. So that's a potential solution to bring it in-house, but I'm not sure the schools would like that.
Thank you, Dan. As always, great to have you back on. Dan Lust, sports law attorney and analyst, who has been year after year after year after year awarded by the state of New York of being one of the rising young stars in the law business. So we appreciate his time.